Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning. I apologize for whatever's going on outside the window. I expect you can hear it. Before we call the case, I want to cover a couple of things with the lawyers. One, we appreciate you and your clients agreeing to proceed with this process, oral arguments by Zoom. Without it, the court pretty much would have shut down business. But it's been working very, very well thanks to the AOC IT people and Ms. Dempsey and folks out of Mr. Hibner's office. If we should have any technical problems, we'll just take a pause and we'll work through it, but things have been going well, so I don't anticipate any. Call the case, please.
St. George Holdings, LLC versus James D. Hutcherson.
We'll hear from the appellant.
Good morning. May it please the court, my name is Garrett Swartwood, and I'm here on behalf of the St. George Holdings, LLC, the appellant in this court, and the plaintiff in the trial court below. I would request from the court 3 minutes for rebuttal argument.
That'll be fine.
And I'm with the Knoxville Bar with the firm of Long, Ragsdale, and Waters. We are here today on an appeal that involves 3 issues. All of these issues arise from a case that involves an attempt to restore the St. George Hotel in Chattanooga. The issues that we've brought before the court are whether the trial court erred in granting a motion for summary judgment, whether the trial court erred in denying a demand for jury trial on the defendant's counterclaim, and having had a trial, whether the trial court then erred in granting specific performance. And so of all these 3 issues, in my limited amount of time, I really wanted to emphasize the waiver of the jury trial issue. You know, the case ultimately did go to a trial, despite the granting of the motion for summary judgment. The summary judgment only dismissed the plaintiff's claims and not the defendant's counterclaims, which were to enforce basically the same transaction. So the fact that it went to trial but did not go to a jury trial is particularly critical. And if the court was to rule that the trial court erred in denying the jury trial, that issue might very well pretermit the issue concerning the trial court's ruling at the conclusion of that trial, which was a ruling of specific performance. So I do want to focus some time on the jury waiver issue, which I think is particularly important. So I don't mean to go through all the facts of the case. Obviously, we've briefed all that. I do want to touch on very briefly a bit of the history of this case and what happened in the trial court below, particularly as it relates to this jury waiver issue. As the court knows, Marta Alder, who's a principal of St. George Holdings, spent considerable amount of time and money trying to restore the St. George Hotel in Chattanooga. This is a hotel in downtown Chattanooga. It's across from the Chattanooga Choo Choo. Miss Alder, through St. George Holdings, acquired the property several years ago, and then spent a lot of time and a lot of money trying to develop plans for this property. The problem with the property, and it's a problem that was particularly important in this case, is that it was completely dilapidated. It had been burned out. It had been virtually ruined with the exception of a facade. And even that facade, as Miss Alder later learned, was significantly damaged and virtually irreparable. So Miss Alder spent all this time trying to develop the property, develop plans for the property on how to restore it as a hotel. And at some point in time, she needed additional funds, additional financing in order to complete that process and get it over the finish line. And that's when she was introduced to the defendant, Mr. Hutcherson. Now, Mr. Hutcherson and St. George Holdings entered into 2 transactions. And I think it's very important for the court to understand that she didn't go to Mr. Hutcherson for a loan at all. She went to him to seek some other financing. He offered, though, to loan money, but he also wanted to have an option to purchase the property. So there were two transactions. And the only transaction that's really brought to the trial court as an issue in the pleadings in the case were the enforcement of the option agreement. That's the agreement that Mr. Hutcherson wanted to enforce, and that's the agreement, that's the transaction that was the subject of the trial court proceedings. So there were cross motions for summary judgment filed. The trial court, both of those motions, by the way, were focused solely on the plaintiff's claims, not on a counterclaim that Mr. Hutcherson had filed to enforce the option agreement. The trial court granted the defendant's motion and then went to trial on the counterclaim for for Mr. Hutcherson's claim to enforce the option agreement. So what went to trial was the option agreement. That was the issue in the case. And the option agreement does not contain a jury waiver at all. The only jury waiver that's present in this case was contained in a separate document that was contained in a deed of trust that was part of the loan transaction. And what the court did was said that broad language in the deed of trust should apply to the claims that were being asserted under the option agreement. And we contend that's an error because these are separate transactions and separate documents. Now, I'd point out that a waiver of a jury trial.
Counsel, let me ask you here before as your time starts to go away. What was the consideration for the option?
It was recited as $100, Your Honor. So separate consideration for $100, that nominal consideration. The price for the exercising the option was the loan balance. So there was a relatedness in that respect. But there's a loan agreement between the parties, and that loan agreement specifies that the consideration for the option was separate consideration from the loan transaction, and it was recited as $100, Your Honor. I would note.
Let me ask you about the language in that paragraph 34. And the last part says, "are arising from any lending relationship between the parties here too." Does that, I mean, why is that not applicable to the option? Because it was all part of one part and parcel.
Because for two reasons, Your Honor.
Okay.
One is that the option is not a lending relationship. The option represents a purchase and sale relationship. So under the option agreement, Mr. Hutcherson would have an option to buy the property. That's not a deed of trust. It's not a lien on the property. It's not security for the loan. In one respect, you have a loan transaction. And on the other hand, you have a purchase and sale transaction. And so I was going to emphasize that lending language in the last line of the jury waiver. I think it's very important, Your Honor, because it reflects that the jury waiver only relates to the lending relationship between the parties, not the relationship of the parties as buyer and seller, which is what they have under the option agreement. I also note, Your Honor, that the option agreement itself clarifies that these are separate transactions and that they're not related and that they're not connected to each other or related to each other. The option language, and I'm referring to section 10H of the option agreement, states, and I should quote it, "The rights and obligations of the parties under this agreement are independent of the rights and obligations of the parties under the loan documents." And the loan documents are specifically defined in the option agreement as being the promissory note, the loan agreement, and the deed of trust, the very same document that contains the jury waiver. So the parties themselves have clarified within their own documents that these are separate transactions and that the option agreement, that's the subject of the lawsuit, was independent of that lending transaction. We defined the word independent in our brief, just quoting from Black's Law Dictionary, but it's synonymous with the term separate. So these are separate transactions. The continuing that definition, independent means not subject to the control, restriction, modification, or limitation from an outside source. So the option agreement is not controlled. It's not limited. It's not controlled in any way by the loan documents. And the parties said that. The parties said that themselves in the option agreement. The waiver of the jury trial, I would point out, notes that it's broadly written. I can see that it's broadly written. It says that any actions arising from the transaction, of course, they're talking about the loan transaction, would be subject to this jury waiver. It also uses the phrase "or connected in any way." And frankly, the word "connected in any way" is even broader, I think, than arising from. I mean, that would seem to suggest anything connected with this loan transaction. But the fact that you have in the option agreement itself, the parties' agreement that it is not connected, that the option agreement is independent, separates the option agreement from the loan transaction and renders that jury waiver inapplicable to the rest of the to the claims that are in this particular case.
Now, let me ask you, if you're correct and it goes to the jury, what is the jury to determine?
Well, the claims that were recited, that were asserted in the counterclaim, was an attempt to enforce the option agreement. So the jury would have to first.
So the jury is going to determine whether or not to grant specific performance.
Well, first, the jury would have to determine liability. So that would be squarely within the jury's determination whether there's liability. And second of all, I think that's correct, Your Honor. The jury would have to determine the remedy and the appropriate remedy. And although that's an equitable remedy, I don't think it's been briefed in the court, in the briefings before the court. I think with proper jury instructions, the jury would be able to determine whether or not specific performance is a correct sort of remedy in this particular case, an appropriate remedy in this case.
All right, and assume the jury decided no, assuming you're right, and the jury could determine whether or not to award specific performance, and assume the jury determined not to, determined just to award damages. What would the damages be for the jury finds a breach of the option agreement and decides no specific performance? What do you say the jury would determine the damages to be?
Well, the damages, obviously, that would be an issue based upon the evidence before the jury. But I would submit and argue to the jury that the appropriate remedy would be the value of the property. So,
the value of the property as it was.
The value of the property probably as the day of trial. I don't know exactly when that date would be pegged. I don't know if it would be very different than it is. I don't know the value of the property has changed very much, Your Honor, over time. But basically, the jury would be awarding the same value to Mr. Hutcherson that he would get if he got the property by giving him an exchange of money for that land. And that would be the value of the property. And in the trial, in this case, we presented appraisal evidence to demonstrate that value. And I think that would be the appropriate remedy, Your Honor.
All right, you have your time for rebuttal.
Thank you.
We're here from the appellee.
Thank you, Your Honor. I'm Gary Patrick here representing Donnie Hutcherson. I think just a short, brief background of the facts is presented by the court and really undisputed that would be appropriate. Mr. Hutcherson loaned St. George Holdings $700,000 for the purpose of getting a development loan to restore this 100-year-old dilapidated building that Mr. Swartwood indicated. St. George defaulted under the terms of the loan documents, and now St. George doesn't like the terms that it specifically agreed to and wants to change those terms. That's really what this lawsuit is about. No more, no less. There were extensive negotiations, Your Honor, between the parties and St. George. And St. George not only had an attorney, Scott Maurice here in Chattanooga was St. George's attorney. It had two other representatives also assisting St. George three counting the total of four counting the principal of St. George during the negotiations. There are a lot of emails going back and forth about the essence of this transaction. And Donnie Hutcherson made it very clear in multiple emails and communications that the only reason that he was making a $700,000 loan was if St. George failed to get a development loan within 12 months, then Donnie Hutcherson would have the option to try to develop the building himself, develop this property. In fact, quote, he said, the sole purpose in making this loan is so he would have a chance to develop it if St. George did not get this development loan. And during the lawsuit, we discovered internal emails, Your Honor, in which the attorney for St. George and the other representatives acknowledged specifically that if St. George failed to get the loan, that St. George could lose the property, but even after the loan, the transaction was done. During the time that St. George had this time to get the loan, the principal, Marta Alder, acknowledged that if she did not get a development loan, she could lose the hotel. So this was known before the transaction, during the transaction. It was no secret, no anything. And that was the sole purpose of making this loan, was that if St. George could not get to the development loan, then Mr. Hutcherson would be given the right to do that. There were extensive negotiations. This wasn't one-sided one way or the other. For example, the 12 months became 18 months later on. So St. George had 18 months to get a loan. Also, the interest they negotiated would not be paid during this 18 months. And it would accrue and only be paid at the end of this 18 months. And there are many other terms that were negotiated as well, Your Honor. And what's amazing, the facts of the case that showed during this 18 months, St. George never one single time submitted a formal application for a development loan to any financial institution. After St. George failed to get the development loan, Mr. Hutcherson gave notification he was exercising his option, and then St. George filed this lawsuit, and that's where we are. Initially, St. George only raised the issue of impossibility of performance, and after we filed a motion for summary judgment, and of course, St. George did too, I think they just threw in the kitchen sink. I think there are 8 or 9 different legal theories that they threw up there, all of which the court rejected. Both sides filed motions for summary judgment, and the trial court found that the defendant, Donnie Hutcherson, was entitled to summary judgment. We went to trial, Your Honor, on the issue of specific performance. And during the trial, in the trial court's opinion, the trial court found that Mr. Hutcherson was credible on all points, and the testimony of St. George's owner was littered with quite significant inconsistencies. So that's the background of that, Your Honor. Now I'd like to address what Mr. Swartwood deems to be one of the most important issues of the 8 or 9 that have been raised, and that's waiver of jury trial. Your Honor obviously knows the case very well because you picked up on paragraph 34 of the deed of trust, and it says exactly what Your Honor showed or quoted. It says that waiver of jury trial on any matter whatsoever arising out of or in any way connected with this transaction or under any amendment, instrument, document, or agreement delivered in connection herewith. The only transaction these parties had was this transaction where he loaned $700,000, got a deed of trust, and received an option to buy the property or get the property in exchange for the debt. And it's not like it's inequitable here because the total amount owing to Mr. Hutcherson is in excess of $900,000 as of the trial date, and the appraisal showed it was like $1 million. So it's a very close scenario, and that's the whole purpose of that. But Mr. Swartwood said these were 2 separate transactions, and that's
Counsel, let me ask you, address specifically his argument that the option agreement itself contains language saying that it's independent, the rights and obligations of the parties here are independent of anything else.
Yes, sir. That's exactly where I was going. Thank you.
Okay, thanks. Sorry to interrupt.
No problem. Thank you for asking the question. The very first page, Your Honor, the second whereas paragraph says this. Whereas Hutcherson has loaned $700,000 to St. George pursuant to the terms of a loan agreement, a promissory note, and secured by a deed of trust, pledging the property, all of even date herewith, the loan agreement, the promissory note, and the deed of trust are collectively referred to as the loan documents. It's not two separate transactions. I know that's what they would like to think. It's not. The very second paragraph says this is one transaction and cites what was actually happened and said and refers to as the loan documents. And it goes on. That's not the only place. On the second page under paragraph 1A, it says after payment in full of the promissory note and satisfaction of all other obligations under the loan documents, the default option shall be null and void and of no legal force in effect. You cannot take this option agreement out of the transaction and say it's separate transaction, because otherwise, if you satisfy the note, if you satisfy the deed of trust, you will still have this option agreement and it would still be in existence. And that simply is not the case. And that's not what the option agreement says. I mean, there are multiple places and multiple references through here about the loan documents. In fact, on page 4, another place, purchase price and payment. In the event the promissory note has been paid in full to the terms thereof prior to closing, the purchase price shall be $700,000. In the event the promissory note has not been paid in full, the purchase price shall be the outstanding principal amount. But also, it goes on and states specifically what happens to the deed of trust. In paragraph 8, Your Honor, of the option agreement, it talks about how the deed of trust gets released. And so you can't look at this as two transactions, because if you did, the loan could be paid and Mr. Hutcherson would still have the option agreement. And that's certainly not what the option agreement says, nor the intent of the parties. And because paragraph 8 specifically says, Mr. Hutcherson agrees to take steps reasonably requested by St. George and the development loan lenders to document the termination of the right of first refusal and the release of the deed of trust. So the option agreement is littered throughout, including the very second paragraph talking about what this transaction is, Your Honor. So this is one transaction, and the deed of trust makes it very clear. And Your Honor can see that this deed of the language on the jury waiver not only is entitled waiver of jury trial, it's all capital letters and independently initialed. That paragraph is initialed by all the parties. That's how important it was. So it is one transaction and not two transactions. We went to trial, Your Honor. Your Honor asked about what a jury trial, what a jury would decide. And in this specific case, we went to trial because of specific performance. The court heard the testimony of both parties, saw the evidence of how important specific performance was. In fact, the transaction would not have happened except for this option to acquire the property. And the judge granted specific performance. And as Your Honor knows, that's only reversible in the event of abuse of discretion. And in light of the judge's holdings about the credibility of the witnesses, then that's not a reversible error. And the damages, Your Honor, if in fact Mr. Hutcherson is not granted specific performance, then he has lost the benefit of the bargain. The only reason he made this loan, and he made it clear, and St. George understood this, and all the representatives of St. George understood this, was if The only reason he made the loan was that if St. George could not get a development loan within what became 18 months, then he would have the right and the opportunity to develop it. And that's what this case is about. And quite honestly, St. George, it didn't happen, and they want to change the terms of the agreement now, Your Honor. Thank you for your patience and listening.
Here's the appellant rebuttal.
Thank you, Your Honor. I'm going to bounce around a little bit to kind of touch on some of these points raised by counsel. First of all, I want to talk about the option agreement and the terms of that agreement. The option agreement, by the way, was drafted by Mr. Hutcherson's counsel, and the deed of trust with the jury waiver was also drafted by Hutcherson's counsel. So to the extent there is some ambiguity about the applicability of these terms, that ought to be construed against the defendant. But I would also note, Your Honor, that it is absolutely true that there are references throughout all these documents to the two different transactions that are going on. But the fact that there are references back and forth doesn't mean that it's a single transaction. The terms of the option agreement never incorporate by reference the terms of the lending agreement. The option agreement identifies in the very same paragraph that Mr. Patrick quoted, the second whereas paragraph, it identifies 3 separate documents as constituting the loan documents, which by itself identifies and clarifies that it's a separate transaction with 3 different documents making up that transaction, with the option agreement being a separate transaction as defined in the document. The court ought to recognize not only does the language of the option agreement identify it as an independent transaction, but I want to emphasize again the nature of these transactions. Giving someone an option is not lending money to them. It is not, as the jury waiver describes it, a lending relationship. It's a purchase and sale relationship. So beyond the form, there's also the substance of these transactions and the fact that they are separate in their nature as well as in the language of the documents. So this case, I want to emphasize or point out that there's a decision that was decided a couple of years ago by the middle section of the Tennessee Court of Appeals. It's Mellow Enterprises case, and I'm familiar with it because I was representing one of the parties in that case, and it had a similar circumstance where you had multiple documents, one of which in that case had an arbitration.
Excuse me, is this case cited in your brief?
It is cited in the brief, Your Honor.
Okay,
Yes.
go ahead. I'm sorry.
And it's, I think, somewhat significant because it has multiple documents involving multiple transactions, and one of them has and they all cross-reference each other, and one of them has an arbitration agreement in it. So it's not a jury waiver, but an arbitration case. And the court in that case decided that the claims that were being asserted were being decided under one document that did not have the arbitration, and therefore it was a separate transaction, and therefore the arbitration agreement did not apply. I think this is a similar case. Finally, with my time running out, I want to point out that this property is not unique. It's not, we don't think it's appropriate for specific performance. It's a commercial property with a dilapidated facade that probably has to be torn down. The only value to it is the value of is the money that Mr. Hutcherson can get for the property. We think that's the appropriate relief that the trial court should grant after a jury trial. Thank you, Your Honor.
All right. Thanks to counsel for both sides for your briefs and your oral arguments. If you would, Madam Clerk, please recess court until 10 o'clock.
This honorable court is in recess until 10 a.m.
Thank you, Your Honor.
Thank you.